I'm glad you asked that, Chef. Nobody's really asking on the ground as a person who's...
The Fifth Amendment of the Constitution protects him from speaking. My name is David Bruno, and I'm with the former Morris County prosecutor, Bob Bianchi. We're partners at the Bianchi Law Group located in Parsippany, New Jersey, and we are back in Morris County. Just recently moved back this month, and it's the first time being back since 2013. So welcome back to Morris, Bob.
Yeah, great to be back in home county, Dave. Looking forward to great success in representing our awesome clients.
We lead a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. Today, we'll be discussing the different levels of culpability under New Jersey Code of Criminal Justice 2C-22. It's important to discuss these culpable mental states because they're part of each and every one of the crimes and offenses found in our code. As criminal defense attorneys, we often look to the statutes and the jury instructions to educate our clients and even our adversaries, our prosecutor adversaries, on what the law actually is. And we're going to be talking about them and the definitions. Bob, give us a little preview of what we're going to learn today about the mens rea.
Well, Dave, you know, when I was prosecutor, I was very specific with our staff that trial notebooks had to be done. And we basically do our defense practice much like we did when we were prosecutors. And in that trial notebook, there's the indictment, and then we have the jury charges underneath. And you refer to those jury charges. What that is the explanation of the law that the judge reads to the jury at the end of the case. Because sometimes law can be complex and a little convoluted. So it's basically in a book, if you will, that the judge will read to them. So we have that with our lawyers when we prepare so that they know what it is that the jury is going to hear. And we give it to our clients because it breaks it down in layman's terms so they can understand it. And what David's getting to here, and it's really, really essential, and I don't think I've seen a video out there, at least in my mind, about it yet. These mental states that we're talking about, purposeful, knowing, reckless, and negligent, are in every single criminal statute. It's called mens rea, the mental state, and actus reus, the actual act itself. And if you have to know those mental states, because many times lawyers make mistakes and people don't get, or the client doesn't understand, that the government has to prove those mental states that are in each statute beyond a reasonable doubt. So if you're reading something that your lawyer's given you to is what the charge is or what the offense is that you're being charged with, when you see words like purposeful or knowing or reckless or negligent, they're not thrown in there by accident. They have a very specific meaning you need to know, and you can go to the Criminal Code 2C2-2, like Dave said, to read it, because sometimes that's the very space the prosecutor won't be able to prove the case beyond a reasonable doubt. Dave?
Let's start off with purposely. A person acts purposely with respect to the nature of his conduct or result thereof, if it is his conscious objective to engage in conduct of that nature or to cause such a result. A person acts purposely with respect to attendant circumstances if he is aware of the existence of such circumstances or he believes or hopes that they exist, with purpose, designed, with design, or equivalent terms have the same meaning. Knowingly, on the other hand, a person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowing, with knowledge, or equivalent terms have the same meaning. Bob, can you explain that to us?
Yeah, sure. So purposeful, which is the hardest thing for prosecutors to prove, means, just like they said, it's almost used the layman's term, intentional. This was what your object was. I pull a gun out and I shoot you. It's not an accident. It's not self-defense. It's not reckless. I basically wrote a note, or I said to you, I'm going to kill you. I caught you cheating on my wife. I pull that gun out, I shoot. That's the conscious object that caused the death of that person. Knowledge is a little less. Knowledge doesn't mean that it was necessarily your purpose or your conscious object to cause that result, but the circumstances were such, the attendant circumstances, that it was practically certain that death, for example, in this case, would be the result of your actions. So you don't have to prove that it was necessarily the intention of the person to do it, but the actions itself made it practically certain that that would be the consequences of your action. It's a distinction with a big difference, Dave.
Yeah, sure. Those two mental states, purpose and knowledge, are by far the most common in each of the statutes. Sometimes they're alone, sometimes they're together in an either or circumstance. Recklessly, on the other hand, is not when somebody has a conscious objective or that circumstances support knowingly. A person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustified risk that the material element exists or will result from the conduct. The risk involved must be to such a severe degree that the purpose of the actor's conduct and the circumstances known to him involve a gross deviation from the standard of conduct that a reasonable person would engage in the same situation. Bob.
Right. So purposeful, the hardest one to prove, that's your conscious object to actually cause the result death. Knowingly is you did something in the attendant circumstances, it was reasonably likely for that to occur. Here, we're not talking about either of those categories. We're talking about negligence on hyper, if you will. It's that it was such gross deviation of a standard of care that it was substantial, so substantial that a jury would find, and that's how we are assessing this as lawyers, that the conduct itself was just reckless, but nevertheless caused the result. You see this a lot of times in the context of a death by auto case. And recklessness could include things like being under the influences of drug or alcohol, or speeding cases, drag racing. We've seen them all. We've prosecuted them all. We've defended many of these cases. It could be texting and driving. It could be not having enough sleep and falling asleep at the wheel. All these kinds of cases have come under the ambit of reckless conduct. Again, you didn't mean to do it. You may not have even been certain that those things were practically going to lead to that result. Nevertheless, the conduct was so reckless that they're going to criminalize that activity as well. So that's where you see that in all sorts of contexts, including aggravated assault, the manslaughter, and like I said, death by auto and other circumstances. Again, the key part here, Dave, is that people look at, see what in the charge they're charged with, and then go to 2C2-2 and read that definition. Perfect example, Dave, I want to give you, all the way from murder to harassment, to a low-level harassment. And we see this in domestic violence cases we handle all the time. The conscious object, remember, purposeful is conscious object, it can be something that makes you guilty of a murder, but it could also be for harassment, because harassment doesn't say knowingly, it doesn't say recklessly, it says if with the purpose to cause, for example, annoyance or alarm. So a lot of times cases will come into our office, especially in a domestic violence context, and somebody will say, I felt harassed, he or she did X, Y, or Z. And all those things very well may be true, but you can win a case by showing a judge that my client did those things, but he didn't do it with the purpose to harass. He did it because of parenting time issues, or he did it because they were, having a dispute about something. So that purpose is really important to understand in the context from the highest level crimes to the lowest level crimes, as is knowledge and reckless.
Yeah, good point, Bob. In the context of death by auto is when somebody recklessly operates their motor vehicle and causes death. And Bob, you talked about the under the influence violation, as well as maybe speeding. There is a part in the law that allows prosecutors to argue that violations of the motor vehicle code amounts to an inference, or it proves recklessness. Now, just because there's an inference doesn't mean it gets the prosecutors automatically there to that reckless requirement that's an element of that crime. Oftentimes, we're on the defense side. We were former prosecutors. We're on the defense side now. Just because somebody's speeding does not mean, in my mind, that is automatically reckless. Reckless is different than speeding, and there are times when we are making arguments that those violations of the motor vehicle code do not amount to recklessly. Even the drunk driving offense could possibly not rise to a level of reckless. Wanted to throw that out there. It's important. Negligently, not really used that often in the criminal code. It is there, defined in the criminal code. Typically speaking, we see negligently used in the civil context. Bob, you want to have any last comments before I wrap it up?
No, Dave, just a great job on explaining those things. And it may sound a little heady, but you can always go to the New Jersey Judiciary website where they have all the jury charges. Like I said, we ensure that our clients get those jury charges from the very beginning of the case because to us, and we're on the aggressive side of lawyering, we start preparing our cases for trial from the day a client comes into the office. And we believe having an educated client is a good thing. And by giving them that information, we could start preparing our case for trial, which ultimately, if we have to try the case, we're prepared from the beginning. But more likely than not, and in some instances, you have a prosecutor that knows you are prepared and that you are preparing the case for trial, which definitely gets your clients, in many instances, the breaks that you need in order to mitigate or lessen the consequences of the conduct that they're charged with.
At the Bianchi Law Group, our team of former prosecutors are always ready to aggressively defend you if the government has brought charges against you. If you or a family member needs an attorney, contact our team of former prosecutors 24/7 at 862-210-8570. We're located in Parsippany. We handle cases all throughout the state of New Jersey, and it is our team's mission to assist you with courage, compassion, and commitment. Thank you, and reach out to us if you need it. We have your back.